Hi, it's Wendy Hernandez with Command the Courtroom. And in this week's video, I want to talk with you about two things that I was reminded of this week and I think that are important for you to remember. So the first thing I want to remind you of is discovery and the power of discovery and not underestimating the power of discovery. I just finished up a case last Friday that had been going on for about a year. And we thought early on that we were going to be able to settle the case because the outcome that my client and I thought was the right outcome seemed fairly obvious to us. And unfortunately, it wasn't that obvious to the other side. So we had to go through a year's worth of litigation, court appearances, attorney's fees, and just lots of headaches and hassles for my clients. She was really getting worn down from the stress, but she persevered. And in the few months before our trial setting, we finally figured out that there's just no way that the other side was going to compromise. So we hit the discovery hard. And what we started doing was propounding interrogatories on the other side, both uniform and non-uniform interrogatories. We propounded some requests for admission upon the other side. And I noticed his deposition. So I took the other side's deposition, and it was a pretty lengthy deposition, and I didn't just go into the deposition unprepared or not having planned anything. I was very strategic about the questions that I asked during the deposition and the information that I wanted to know and that I wanted to come out. One of my goals during every deposition is to get a better understanding of what the other side is going to say during trial and lock them into their answers and to their stories. That way it makes it easier for me to impeach them at trial. So that's what I did exactly during the other party's deposition. And, I thought the deposition went okay. My client was happy with the way the deposition looked, but it really seemed like it didn't make a difference in the scheme of things because here we were continuing to prepare for a trial, and despite the questions that I asked of the other party during the deposition and in my interrogatories and in my request for admission, he didn't seem shaken. He was firm in his position. So fast forward a couple of months after the deposition and after I've done all of these discovery things, and it's time for trial. And in this particular case, there was a guardian ad litem assigned to the case by the court. And the guardian ad litem had reviewed all of the discovery that I propounded on the other side, all of the pleadings that had been filed in the case. And apparently he didn't get to review the deposition that I took of the other side until in the days leading up to trial. And in the days leading up to trial, the guardian ad litem was going to make a recommendation to the judge that was not in my client's favor. And I was feeling a little discouraged about that. Although I didn't voice that to my client, I was just feeling like, oh my gosh, this guardian ad litem is appointed by the court. The court's really going to listen to him, and that's going to make our job all the harder. Well, as it turns out, like I said, in the days before the trial, the guardian ad litem really sunk his teeth into the deposition that I had prepared or that I had done of the other party. And we showed up on the day of trial, the morning of trial, and I was there an hour before trial to meet my client. As it turns out, the guardian ad litem was there early too. And he told me he was hoping that I would show up early because he really wanted to talk to me. And he had told me that he had spent the days before the trial and that most of the night before the trial really looking at the other side's deposition. And that based on the other party's answers during that deposition, the guardian ad litem was switching his position. And he was switching to a position that really made my client happy. And that was, I don't know that it was directly in favor of my client, but it was a position that really my client could live with and that it actually did make her happy. So what ended up happening that morning before the trial is, the judge gave us some time and we spent a good couple of hours outside of the courtroom talking with the other party based on the guardian ad litem's new position, and we reached a settlement. So that's the second point that I want to raise to you today, is that no matter how bleak things look, you really just never know what's going to happen. These cases are unpredictable, especially if there are other people involved, like guardians ad litem or court-appointed investigators or court-appointed advisors or custody evaluators or any sort of third party. You just don't know where things are going to head. So just don't give up. Stay the course, persevere. In this particular case, despite the fact that my client thought that the guardian ad litem was making a recommendation that she didn't agree with, we were prepared to go into court and argue our position and present our best evidence. And we thought that despite that whatever the guardian ad litem was going to recommend, that we could make a pretty good case for her. And we were ready to do that. And it ended up working out in the end. So remember, if you're going through a case, and even if you want to settle the case, make use of those discovery tools that are available to you. Check your state rules and statutes for the rules surrounding interrogatories and requests for admission and deposition, and use them if you think they would benefit you. And then the second big lesson is that whoever you are and wherever you are in your case, don't ever give up. So if you haven't already liked Command the Courtroom on Facebook, go to Facebook, like us. Subscribe to Command the Courtroom on YouTube, and if you do, you'll get notified of my weekly videos as they come out. I release them every Thursday. If you haven't signed up for the Best Interest Checklist, go to commandthecourtroom.com and sign up. Until next week, keep on trucking, and remember to command the courtroom.